All right, welcome back. Now we're going to get into the section concerning the Louisiana Concealed Handgun Permit laws and administrative rules. And you can see on there, this is a document, and it's published by the Department of Public Safety and Corrections of the Office of the State Police. And so you can actually access this rule book online. You can either Google in Louisiana Concealed Handgun Laws and Administrative Rules or Rule Book PDF, or go to the website and follow the links. But at any rate, this is good information. It is the laws contained in there. I want to say beforehand in this class that we're to do a review of this and to go over this, focusing on a couple different things. And so when we focus on those, again, we're just like you. I'm not an attorney. We're an instructor. We go over the information. We give it to you. But you are responsible for your actions, and you are responsible to know the laws. And so we are concentrating our information on certain sections of the entire law and of the rule book. But at the end of the day, it's your responsibility as a Louisiana citizen and a concealed carry permit holder to know the laws yourself. And so make sure you can go and get this PDF on your phone, put it in iBooks or another PDF reader, have it on your computer, or you can print it out. And it is good to go over it, and so you will want to know the laws so that you can abide by those laws and carry as a concerned citizen in Louisiana and as a concealed carry permit holder, that you can obey all those laws of the land. So first, as you notice on the objectives here, we're going to look at the use of deadly force. What is deadly force? When are you able to use deadly force? When are you not supposed to use, or when can you not use deadly force? We're also going to demonstrate an understanding of conflict resolution. And so obviously the use of deadly force is predicated upon, or it is instituted upon, a conflict taking place. And so if at all possible, we can resolve that conflict without it going to deadly force, then we're in a better situation because lives are at stake. And so we can't fail to understand the fact that we're talking about real lives. You're a real human being. I'm a real human being. The person that you may get into a conflict with, they're a real human being also. They have real parents. They may have real family. We have real parents. We have real family members, people that love us and care about us. And so we want to avoid conflict altogether if possible. And we're going to talk about that as far as conflict resolution goes in this section. And then also we're going to demonstrate an understanding of child access to firearm prevention and safety. Of all people, we definitely want to keep our children safe. We want to keep children of innocent bystanders safe. We want to keep children in all cases safe from accessing firearms. And so we'll talk about what that means also to keep children safe from the access to firearms from a prevention and a safety standpoint. So this is going to include a review of revised statute 1418 in the Louisiana Law Code through revised statute 1422. And so we're going to concentrate on those areas, and we may mention other areas, but that's going to be the bulk of our concentration for deadly force, conflict resolution, and child access prevention. And we're going to concentrate specifically on pages 29 through 30 of the Louisiana Law and Administration Rule Book. And so you can get that PDF online. You can go to the State Police website and download that PDF on your smartphone, on your tablet, or on your computer. And that would be pages 29 through 30 specifically. I'm going to open up that PDF online here. It's going to take the place of this screen, and so we will be able to see that together as we walk through this. And again, if you have any questions, write those questions down, bring them to the range time, or shoot me an email, and we'll get your questions answered for you. We want you to understand as much as possible the rules and the laws concerning concealed carry permits in the state of Louisiana. All right, so I've got this PDF opened up on the screen so that I can read it and so that you can see it. And this is Louisiana Revised Statute 1418. And what I want to mention up front is something I mentioned earlier in the course, is that your concealed carry permit, by law, it authorizes you to carry a concealed carry firearm. It allows you to carry a firearm on your person. We already have open carry laws for that allow you to do that. But this concealed carry permit and the training and the actual permit itself under the law allows you to carry your gun completely concealed on your person in certain situations and in certain places. It does not authorize you to use that gun. There are other laws that authorize you to use that, and that's what we're about to get into here. Justification, if you see up there LRS 1418, we're going to look at the general provisions of justification. This is the general law concerning the term justification and what does it mean. And then we're going to look at the specifics as it pertains to deadly force and conflict resolution. So, read with me, and I know this is long, drawn-out legal stuff, but this is what we're supposed to concentrate on. This is what Louisiana state law wants us to concentrate on, and so it's important, and we need to go over it. So, the fact that an offender's conduct is justifiable, and let me mention right there, they refer to offender as in an offensive manner. It doesn't mean as in a guilty party, but in the offensive manner, the one causing the harm by doing this certain action. So again, this is generally talking about justification. The fact that an offender's conduct is justifiable, although otherwise criminal, shall constitute a defense to prosecution for any crime based on that conduct. This defense of justification can be claimed under the following circumstances. So let's talk about the first phrase, and then we'll get into what circumstances this applies in. So what is justification? It's saying you've done something that would be considered criminal in other circumstances. However, but because of the circumstances, it's not criminal, but it constitutes a defense that is a defense that is going to claim you not guilty for what you've done. So let me give you an example. Normally, it is a crime to hit somebody. However, in specific instances, it is justifiable to use force like hitting somebody, tackling someone, pushing someone to accomplish a certain thing under the law. Self-defense, or even we'll see fulfillment of a public duty. If you're a police officer, or a firefighter, or someone else that has a public service, sometimes you may have to participate in actions that normally would be criminal under the law, but because of the circumstances surrounding the situation, they're not considered criminal, but it actually is considered innocent or defensible to prosecution for any crime based on that conduct. So this defense of justification can be claimed under the following circumstances. Again, we're talking general. We're not talking about deadly force or killing someone. Just in general terms. 1, when the offender, that is the person actually doing the conduct, whatever that is an apparently authorized and reasonable fulfillment of any duties of public office. That means someone who is in public office and they have committed some kind of conduct that would normally be considered criminal because of what they've done. If they have reasonably acted in fulfilling their duty of public office, their conduct is now constitutes a defense to prosecution for anything that would be considered criminal based on that conduct. Let's look at number 2, and you'll understand this a little more where we're going with this. When the offender's conduct is a reasonable accomplishment of an arrest, which is lawful under the Code of Criminal Procedure. Okay. So now we're talking about police officers or other officers who have the power of arrest. And so we know we've seen many news stories where people resist arrest or where it is necessary to use force to arrest somebody. They flee from the officer, and the officer has to actually run after them, tackle them to the ground, subdue them, and then put handcuffs on them. So it is an arrest. Normally, if you go out and you run after someone and tackle them and put them in handcuffs, that would be considered criminal. It would be considered at the least assault. Well, when it's fulfilling this officer's duty to arrest a potential criminal or those being accused of a crime, it is now defensible under the law. Now, it has to be reasonable. And so I want to talk about that for a minute, because you're going to notice in number 1, the term reasonable. In number 2, the term reasonable. In number 4, the term reasonable. Reasonable, reasonable, reasonable. It has to be reasoned out to the average individual, the normal, rational mind of the civilization around us, that your conduct is reasonable under the law for you to be justified. In other words, you're going to be judged by 12 people. We're going to get to that. And when you have criminal conduct that comes before a court of law, it has to reason out in the minds of the judge and the jury that it was reasonable what you did considering the circumstances. And so they have to consider the officer's actions. They have to consider the citizen's actions, the person in public duty or public office's actions, and say, given the set of circumstances, this person was fleeing, was it reasonable for this officer to use force, tackle that person down, and put handcuffs on him to accomplish arrest? If they say yes, it was reasonable, they evaluate the situation. Was the person running? What was the probable cause? They evaluate all the legal situations surrounding what happened when this conduct took place of the offender, and they say, does this constitute a justifiable situation, justifiable conduct? So look at number 3 with me. When for any reason the offender's conduct is authorized by law, or 4, we'll go into 4, when the offender's conduct is reasonable discipline of minors by their parents, tutors, or teachers. So now listen and understand this, that this doesn't just extend to public office. It doesn't just extend to law enforcement or first responders or any other people authorized by law, but it also goes to the discipline of minors by parents, tutors, or teachers. And again, it's reasonable discipline. So normally it is wrong to make any physical contact with a minor for the sake of discipline. However, parents, tutors, or teachers are authorized by law, and there are other laws governing this actual authorization. Parents are authorized, we'll take that simple one, to spank their children. Normally, if you strike a child and it's not in the course of reasonable discipline, it is against the law, and you can be brought up on charges for assault. Now, the law makes provision for the discipline of children by their parents. And so you can see when the conduct is reasonable under the law, and that's deemed reasonable by those people investigating the crime and then trying the crime, it will be justifiable. Notice number 5, when the crime consists of a failure to perform an affirmative duty, and the failure to perform is caused by physical impossibility. So we have situations where doctors and or nurses happen to be at an accident scene, let's say, and they cannot perform life-saving CPR to someone who has now life-threatening injuries at an accident scene. So when the crime, normally it would be a crime under the law for someone with the ability to save a life, and they neglect that. They neglect to save that person's life because they just stand by and they don't do anything. However, think about an accident scene, and there is a nurse or a doctor or someone else who has the ability and the knowledge to render care, and yet they're inaccessible. It is physically impossible for them to get to the person in the car because the car is so wrecked. They cannot be brought up on charges and they cannot be prosecuted. It'll be indefensible. It'll constitute a justified defense to say, Your Honor, we did everything possible to try and get to the person, and we couldn't physically get to the person, and they died. And they tried to, but they couldn't. So you understand the law makes provision for an affirmative duty and the failure to perform it because of it's physically impossible to do it. All right, number 6, when any crime except murder is committed through the compulsion of threats by another of death or great bodily harm, and the offender reasonably believes the person making the threats is present and would immediately carry out the threats if the crime were not committed. So, there's a crime, not a murder crime. It's being committed through the compulsion of threats. And so extortion or anything else like that, somebody is threatening you, threatening another of death or great bodily harm, threatening you of death or great bodily harm, and the offender, meaning the person who's about to commit the conduct, reasonably believes the person making the threats is present and would immediately carry out the threats if the crime were not committed. In other words, you're trying to prevent this situation. And it is reasonable to believe before it happens that you believe it is going to be carried out by this person. You can be justified. You are justified under the law. And so somebody is making a threat to harm you or harm your family, and you believe them. And they're making threats, they're there, and you believe that they would immediately, they have to be there, not calling you on the phone, not sending you a letter, but they're there in your presence. And you believe if they would immediately carry out this threat, even though they haven't committed the crime yet, it is reasonable to believe by their language, by their demeanor, and by the circumstances surrounding the situation that yes, they're going to do this. You are justified in your conduct to stop them physically or to do something else that normally would be considered criminal on your part, but you use it now to defend others or defend yourself or to stop this crime that is about to take place. So hopefully that makes sense to you. Or number 7, when the offender's conduct is in defense of persons or property under any of the circumstances described in Article 19 through 22, and we're going to get to that as we go on. So justification as a general provision. Normally your actions would be considered criminal, but because of the extenuating or surrounding circumstances, your actions are not only not considered criminal, but they are justified under the law. In other words, the law stands on your side and now says you are innocent and you are not guilty at all. The greatest example we see is from America and how we got this provision of justification. We've gotten this handed down to us because we were founded as a Judeo-Christian nation. The American Constitution contains much from the Bible that our forefathers actually put together when they wrote the Constitution. And so when we see this provision of justification, it comes straight from the Bible, and it focuses and centers upon the cross of Jesus Christ. We know that 2,000 years ago, in real time, in real history, the man Jesus Christ, who was the Son of God, he hung upon a Roman cross and died to make justification for all those who would believe in Him. And so it looks like this, to get it clear in your mind. We have broken the law. We've broken the law of God, and we're talking about the law of man here for justification. And that's an extension of the law of God. And so the law of God says, do not commit murder. So normally, under the law, we would see that we are guilty of murder. But in this justification provision, it treats us as if we did not commit murder and that our actions are justifiable. And this is what Christ did upon the cross. He stood before the judge of the universe, and He gave His life in exchange to set us free, to forgive our sins. It's as easy as this. We have broken the law and we deserve punishment. But Christ, because of His actions, not ours, because He kept the law perfectly, dies in our place and justifies us before the God of the universe, the judge of the universe. So that on the day we stand before Him on Judgment Day and give account of our lives, by faith in Him we will be found innocent and not guilty. We will be justified, treated as innocent before the law. And that's what this provision is based upon. And I know you may not agree with that, maybe from a religious standpoint or a life philosophical standpoint, but that just happens to be the history of our country. That's where this provision comes from. It's why we have these provisions in the law. And so to know the history behind that and to know that the God who created you, the God who created me, has put this provision into the hearts and minds of men that we can find each other justified in certain senses based on the principle from the Bible really is an amazing fact of our country. And so these are where these general provisions under the law come from. But now we're going to get into the specifics. And I'm going to scroll up here to 19. The use of force or violence in defense. And this is Louisiana Revised Statute 1419. And we'll look at provision A. The use of force or violence upon a person of another is justifiable under the law when it committed for the purpose of preventing a forcible offense against the person or a forcible offense or trespass against property in a person's lawful possession, provided that the force or violence used must be reasonable and apparently necessary to prevent the offense or such offense, and that this section shall not apply where the force or violence results in a homicide. You're going to see now that we're going to walk through these provisions without considering deadly force, just forcible offenses that are not deadly, and then we're going to repeat it in deadly force. And you're not going to see much difference between the two, but we need to look at both of them. We're talking about the use of force or violence upon the person of another and it being justifiable. So, first, it has to be committed for the purpose of preventing a forcible offense against the person. So, someone is committing using force against you, and you use force, violence, to prevent this force being committed against you. And so it's reasonable and apparently necessary. There's that word again, reasonable and apparently necessary to prevent the offense. And so the offense is going to happen, you know it is, and you use force to prevent force being used against you. And so we call this reasonable force or justifiable force. Then look at provision B. For the purposes of this section, there shall be a presumption that a person lawfully inside a dwelling, place of business, or motor vehicle held a reasonable belief that the use of force or violence was necessary to prevent unlawful entry thereto, or to compel an unlawful intruder to leave the premises or motor vehicle if both of the following occur. So first, before we get into the two things that need to happen, find out what we're talking about. We're talking about you're inside a home, a business, or a vehicle, and something is about to happen, and you reasonably believe that you must use force or violence to prevent somebody from getting into where you are. So, you're standing in a business, you're standing in your house, and here comes a group of burly-looking men with baseball bats. And they're saying things that you don't want to hear and that you wouldn't want anybody else to hear. And here they come, and they're coming at light speed. You know, beyond a reasonable doubt, nothing good is going to happen about this. And so your reasonable belief and that of the reasonable belief of others would be, I need to do something. I'm going to need to use force or violence to prevent unlawful entry to this house or to compel them to leave. And two things have to go on. The person against whom the force or violence was used, that means the big burly guy with the bat, he has to be in the process of unlawfully and forcibly entering, or had already unlawfully and forcibly entered the dwelling, place of business, or motor vehicle where you are. So he's got to be in process. So he's coming, and he's coming in, or he's already there when you get there. Now it is reasonably held that you can use force. Or two, the person who used force or violence knew or had reason to believe that an unlawful and forcible entry was occurring or had occurred. So you either knew it as a fact or you had definite reason to believe that they were coming in via what you saw or what you were told or circumstances that were all put together. So, for the purpose of this section, you have to presume that we are there lawfully. In other words, it's your house or someone else's house. You have the lawful right to be there. It's your car or it's your business, or you have the lawful right to be in that car at that business. We assume that. We presume that. And now, if those two things are true, that it's in process and they're unlawfully and forcibly entering, the guy with the baseball bat is coming in, or he already did come in, you can use force to stop him or to compel him to leave. Or the person used force or violence, or you knew or had reason to believe that unlawful and forcible entry was occurring or it had occurred. So in either one of those cases, you are justified under the law to use force. All right. C, a person who is not engaged in an unlawful activity and who is in the place where he or she has a right to be shall have no duty to retreat before using force or violence as provided for in this section, and may stand his or her ground and meet force with force. This is what's known in Louisiana and other states as stand your ground or castle doctrine. But it doesn't just apply to your castle or your home. It is stand your ground where you are, whether you're in a public place, private place, your home, your vehicle, your office, or another public place where you are lawfully allowed to be, and you are lawfully there. You have no duty to retreat. And what that means is you can use force or violence as provided for in this section, and you can stand your ground. So you're lawfully there. You don't have to turn and run because the burly guy is coming with the baseball bat. You have no duty under the law. You can meet force with force, and you can compel that person to leave or stop doing what he was about to do. Now, I want you to hear me. I want you to hear me clearly. Some people may say, well, that's wimpy or that's not very manly. It may not be the best choice for you to meet that burly man with the baseball bat. Your best choice may be to run or press the gas if you're in your car and take off, or lock the door to the business and call 911. That may be your best option. However, what the law is saying, you don't have to. In other words, it is not your responsibility under the law to run from the man with the baseball bat. You can stand ground, meet him face to face, and use force on force to stop him or to compel him to leave. And now that's where D comes in. If you look under C there, it says, no finder of fact shall be permitted to consider the possibility of retreat as a factor in determining whether or not the person who used force or violence in defense of his person or property had a reasonable belief that force or violence was reasonable and apparently necessary to prevent a forcible offense or to prevent the unlawful entry. Okay, all that is to say this: no judge, no jury, no police officer, no investigator, no finder of fact is permitted to consider the possibility of retreat in your case as a factor in determining whether or not you use force or not, or you were to use force or not. And so they can't say, well, you could have turned away from the guy with the baseball bat and run. And so, but because you didn't, now you can't claim self-defense in there, or you're not justified under the law. No finder of fact can consider the possibility of retreat. In other words, stand your ground means stand your ground. It is not even going to enter into the courtroom, the litigation, the possibility of retreat. Nobody can base a case on it and say you should have ran, you should have turned to run. Now, again, it doesn't mean that's not the best thing for you. There are times to run and there are times to stand and fight, and we'll talk a little bit more about that in the following sections. But you cannot be held liable under the law because you didn't run and you stood and defended yourself or defended the lives or property of someone else. So that brings us on to section 20. We're not just talking about justifiable force, but now we're talking justifiable homicide. And so all of the section before that was talking about justifiable force, but it wasn't talking about deadly force. And now we're going to get into deadly force under the law with Louisiana Revised Statute 1420. All right, a homicide is justifiable. Now we're going to be given 4 sets of circumstances which are represented by the letters A, B, C, and D, and then they have subpoints underneath them. But a justifiable homicide, a homicide is justifiable when committed in self-defense by one who reasonably believes that he is in imminent danger of losing his life or receiving great bodily harm, and that the killing of the other person is necessary to save himself from that danger. Okay, so when committed in self-defense, and I reasonably believe that I am in imminent danger of losing my life or receiving great bodily harm. Now let's define great bodily harm. We know what losing life is, and it's imminent danger. So let's start with imminent danger. That means right now this is occurring. Not tomorrow, not in a couple minutes even, not in a half hour, an hour, or, it is an immediate danger. It is in front of me right now, and my life is going to be taken from me. So homicide, that means the killing of another person is justifiable when imminent danger is present, or the threat of imminent danger of losing life. And then it also says, or receiving great bodily harm. And great bodily harm under the law constitutes life-threatening injuries that if you didn't receive immediate medical attention, that you would succumb to those injuries, that you would die from those injuries shortly thereafter. And so we have imminent danger of losing your life, dying immediately, or receiving such injury that if you don't get prompt medical attention, you will die from those injuries. And so we're saying because of that, it is necessary to get rid of the threat, the killing of another person. And that's when homicide is justified in that sense. Look at 2 under A. Also, when committed for the purpose of preventing a violent or forcible felony involving danger to life or of great bodily harm by one who reasonably believes that such an offense is about to be committed and that such action is necessary for its prevention. The circumstances must be sufficient to excite the fear of a reasonable person, and that there will be serious danger to his own life or a person if he attempted to prevent the felony without the killing. And so now we're not talking about just self-defense. We are talking about any violent or forcible felony, breaking and entering, bank robbery, the robbing of a store, the robbing of a gas station, terrorist attack, any mass murder situation, or any situation that a felony is involved in. The danger to life and great bodily harm exists by that, and the person who is now trying to stop that reasonably believes that this offense is about to be committed, or it is actually being committed, and that it is necessary to use death. It is necessary to use deadly force to prevent such actions. And the circumstances must be sufficient to excite the fear of a reasonable person. That means the jury of 12 again, all the circumstances combined together. Yes, I saw the man come into the mall. He was carrying an AK-47. He was dressed in dark tactical gear, and he was shouting things that made me reasonably believe that he was a terrorist. And so it excited my fear, given the situation in America, given the things we've gone through in history, and given the current state of affairs and my understanding of terrorist attack and how they take place, and typically what it looks like. My fear was excited to the point where I believe this man was about to start killing other people, and so I deemed it necessary under the law to take reasonable action against this person, which included justifiable homicide. So, when committed against, for the purpose of preventing a violent or forcible felony involving danger to life or great bodily harm, that will be a circumstance for that. And you have to reasonably believe that, and then other people, their fear has to be excited as well. People in the mall were running and screaming. They were taking off because this man was there with this gun. And then I saw no other option than to take action. So that's number 2. Number 3, when committed against a person whom one reasonably believes is likely to use any unlawful force against a person present in a dwelling or a place of business, or when committed against a person whom one reasonably believes is attempting to use any unlawful force against a person present in a motor vehicle, as defined in RS 3240, while committing or attempting to commit a burglary or robbery of such dwelling, business, or motor vehicle. And so now this goes to more specifics of burglary, robbery of the business, motor vehicle, or a house. And so we can, when we understand the situation and see the circumstances as a business being robbed, a house being robbed, or a person in a vehicle being robbed, or us in the vehicle being robbed, or there's unlawful force against a person in the motor vehicle, we can use force that's justifiable under the law to prevent burglary, robbery of a dwelling, business, or motor vehicle under the law when force is being used. And so we can use force on force up to and including justifiable homicide in any of those situations, in any of those locations, to prevent or to stop this unlawful force against a person in the car, in the house, or in the business. And then also look at 4A. When committed by a person lawfully inside a dwelling, place of business, or a motor vehicle as defined in Revised Statute 32-140 against a person who is attempting to make an unlawful entry into the dwelling, place of business, or motor vehicle, or who has made an unlawful entry into the dwelling, place of business, or motor vehicle, and the person committing the homicide reasonably believes that the use of deadly force is necessary to prevent the entry, to compel the intruder to leave the premises of the motor vehicle. So you're either stopping force, as in 3, or you're compelling the person to leave. In any of those situations, you reasonably believe the force in the homicide was necessary, deadly force was necessary to prevent the entry or to stop the force or the forcible felony against you or against someone else, we'll see in the provisions of the law. And we go on to B. Hang in there with me. The provisions of this paragraph shall not apply when the person committing the homicide is engaged at the time of a homicide in the acquisition of, the distribution of, or possession of, with intent to distribute a controlled dangerous substance in violation of the provisions of the Uniform Controlled Dangerous Substance Law. So, drug users, drug buyers, drug dealers, when they're in the process of selling or buying, this does not apply to them because they're in the act of a crime. They cannot claim self-defense or justifiable homicide. Years ago in a small town in Louisiana, there was a case where 2 young men got together and they were going to go to a quote-unquote party. And they were going to go to this party, and when they got to this party, a man met them there with an AK-47. And that man held them at gunpoint and actually knocked out both of the individuals. And he knocked them to the ground with the butt of the gun. And these 2 young men were knocked out on the ground, and when one of them, the one came to his senses, he saw his other guy that he came to the party with on the ground and with an AK-47 pointed at his head as if he were about to be executed. And so the one who woke up seeing this, he had a Glock 23, that's a 40 caliber compact size Glock, and he had it on his person. He actually drew the weapon and shot one shot. The weapon actually malfunctioned, or he malfunctioned it, whatever the case. But he shot one time into the stomach of the man with the AK-47, and that man fell and died on the spot. This man claimed self-defense, and he did, under the law, he was justified in his homicide because they could not prove that this was a drug deal gone bad. There were no drugs. They did find money, but they did not find any drugs. And so they couldn't prove beyond a shadow of a doubt under the law that it was a drug deal. But for all intents and purposes, everyone understood it as a drug deal gone bad, except for, obviously, the person on trial involved. So none of this applies when the person committing the homicide is engaged in selling or buying narcotics or uniform controlled dangerous substances. For Also look at B. For the purposes of this section, there shall be a presumption that a person lawfully inside a dwelling, place of business, or motor vehicle held a reasonable belief that the use of deadly force was necessary to prevent unlawful entry thereto, or to compel an unlawful intruder to leave the premises or motor vehicle, if both the following occur. So now we look at 1 and 2 under B. The person against whom deadly force was used was in the process of unlawful and forcible entry and had unlawfully and forcibly entered the dwelling, place of business, or motor vehicle. Or the person who used deadly force knew or had reason to believe that an unlawful and forcible entry was occurring or had occurred. So again, we have to presume certain things under the law, and that we're there legally, and then we also understand the person against whom deadly force was used, that's the bad guy, was in process of forcible entering, meaning they were breaking into the place or using force to enter the place. All right, and C, a person who is not engaged in unlawful activity and who is in a place where he or she has a right to be shall have no duty to retreat before using deadly force as provided for in this section, and may stand his or her ground and meet force with force. Again, this is identical except with use of deadly force versus regular force or non-deadly force in the previous section that we talked about. And so there is no duty to retreat, and no finder of fact shall be permitted to consider the possibility of retreat as a factor in determining whether or not the person who used deadly force had a reasonable belief that they should have done that. And so it is the same as what we talked about with using force, except now justifiable homicide, the justifiable killing of another, you can stand your ground and meet force with force, including taking the life of that person or persons. You have no duty to retreat. As long as you're not engaged in unlawful activity and you have a right to be in the place where you are. In other words, your house or someone else's house you have the right to be in, your car or someone else's car you have the right to be in, or a public place that you have the right to be in, you have no duty to retreat, and you can meet force with force up into and including deadly force or homicide, and it will be justifiable under the law. And so hopefully those things make sense to you there. We have to cover just a couple more things here. If you'll notice in LRS 1421, under 21, the aggressor cannot claim self-defense. And so a person who is the aggressor, who brings on a difficulty, cannot claim the right of self-defense unless he withdraws from the conflict in good faith and in such a matter that his adversary knows or should know that he desires to withdraw and discontinue the conflict. What does all that mean? It means this. I start a pushing match with someone else, and I am the aggressor. I bump into him and I push him, and I bring on a conflict, and we're about to fight, or we are fighting, and that person reaches for a gun, and then I grab my gun and I shoot them. I cannot claim self-defense because I brought on the difficulty. I was the instigator. Unless I withdraw, in other words, we're pushing, and we go to fight, he produces a gun, I don't produce my gun, I say, whoa, 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 man, I didn't know it was going to go to guns. I stop, I turn around, and I walk away. I say, I'm done. I'm not fighting you anymore. And in good faith, I really mean it. And my adversary, or the person against me, knows that I've withdrawn. And yet he follows me anyway and proceeds to beat on me and attack me. Now he becomes the aggressor. And so the table is turned, and I can use self-defense in that situation. But an aggressor cannot claim self-defense. You cannot go pick a fight with somebody. The table gets turned on you, and all of a sudden you claim self-defense, that you had to shoot that person or hurt that person because they attacked you when you actually attacked them. And so they would be the one in the right claiming self-defense, not you. So hopefully that makes sense. LRS 1421, the aggressor cannot claim self-defense. So don't ever put yourself in that situation. And really, as you notice, as we go through all this, it's just common sense applies in all these situations. Love your neighbor as yourself. Go about your own business and don't start trouble with anybody else, and use common sense when you're defending yourself. And that's all it comes down to, is reasonable understanding of who we are as people and what we need to do to stay alive in life. So, look at 14:22. In the defense of others, it is justifiable to use force or violence or to kill in the defense of another person when it is reasonably apparent that the person attacked could have justifiably used such means himself, and when it is reasonably believed that such intervention is necessary to protect the other person. So, what they're talking about here is you are not the person under attack, but you are now the witness to another person who is being attacked or that force is being used against. And they could have justifiably used self-defense or used homicide themselves, but they were unable to. And you're there. And so it's reasonable to believe that you intervene. You come in between the two and you use force to defend this other person. So, in defense of others. And we're going to look at one example on video of this defense of others and how that actually plays out in real life and what it looks like in an actual case. And we'll look at that video a little bit later. Okay, that was a concentration on the use of deadly force, and now what we're going to do is look through some other portions of the rule book that are good for you to know and that we feel in this course you ought to know. Okay, now we want to talk about revoking your permit. How can you lose your permit? Just so you know the circumstances of what you're not supposed to do when you get your concealed handgun permit. So once it's issued, you may carry and conceal your handgun while you are sober only, not under the influence of alcohol or under a controlled dangerous substance. So, either alcohol or a controlled dangerous substance, you cannot carry your firearm even if you have a permit. It's not legal to do so. And so while you're under the influence of alcohol or a controlled dangerous substance or otherwise, your otherwise lawful permit is considered automatically suspended and it's not valid. And so the permittee will be considered under the influence as evidenced by a blood alcohol reading of 0.05% or greater by weight of alcohol in the blood, or when a blood test or urine test shows any confirmed presence of a controlled dangerous substance. So all in all, in short, do not use alcohol or drugs and carry your firearm. You shouldn't use drugs at all. And if you do drink alcohol, I would say in moderation. At least that's what I believe. But if you use it at all, you cannot carry your firearm. And so remember that. If you use alcohol or drugs at all, your permit, if you're carrying it, it is not valid and it is automatically suspended if you get caught doing that. Also, a permittee armed with a handgun, if you look at Section 2 there, in accordance with this section, shall notify any police officer who approaches the permittee in an official manner or with an identified official purpose that he has a weapon on his person. Submit to a pat-down and allow the officer to temporarily disarm him. So, whenever a law enforcement officer is made aware that an individual is carrying a concealed handgun and the law enforcement officer has reasonable grounds to believe that that individual is under the influence of alcohol or a controlled dangerous substance, the officer may take temporary possession of the handgun and request submission of the individual to a department-certified chemical test for a determination of the chemical status of the person. So, anytime an officer deems necessary, if you're under the influence of alcohol or drugs, they're going to disarm you and they're going to test you. And if you're found that you are legally under the influence, your permit is no longer valid at all. So, also with that, anytime a police officer contacts you in an official manner, you have the duty under the law and you must notify them that you are carrying concealed. And so you just simply tell the officer in that manner. You wait, you're not rude about it or anything. You keep your hands where he can see them or where she can see them. And you say, officer, I understand under the law that you've made official contact with me and I need to notify you that I am a concealed carry permit holder and I do have my gun on my person. And depending on the circumstance, they may choose to disarm you and they're free to do that and you need to submit to that. They may pat you down and disarm you and they're free to do that and you should submit to that. Or they may tell you, hey, just keep your hands where I can see them and we won't have any problem. I've been contacted in an official manner, not for a crime, by police officers, and I did tell them that I was carrying, and they told me, hey, that's no problem. Keep your hands right where I can see them, and we'll have no issue at all. Okay, now let's talk about some places where you cannot carry your firearm or your concealed handgun. If you look at M here, no concealed handgun permit shall be valid or entitle any permittee to carry a concealed weapon in any facility, building, location, zone, or area in which firearms are banned by the state or federal law. So N, no concealed handgun may be carried into, and no concealed handgun permit issued pursuant to this section shall authorize or entitle a permittee to carry a concealed handgun in any of the following. 1. A law enforcement office, station, or building. That means a police station or any other building of law enforcement. You cannot go to the city, the county, the sheriff, the state, any law enforcement office, station, or building. You cannot carry your concealed handgun in that, or any handgun or any gun, into that place. A detention facility, prison, or jail. So you cannot go to Angola and visit the people there and bring your handgun. You cannot bring it into any detention facility, any sub-facility, or anything like that. Look at number 3, a courthouse or courtroom, provided that a judge may carry such a weapon in his or own courtroom. And so the judge can carry concealed in his or own courtroom. A visiting judge cannot. And you cannot carry into court. And so when you go to court, that's why they have the metal detectors. Leave your gun in your vehicle or leave your gun at home. You cannot take it into the courthouse or the courtroom. A polling place, and a lot of people don't know this, so when it's voting time and you're going down to use the polls, you cannot bring your gun into the polling place, your local, and it doesn't matter what place it is. So some have a designated building, some use a fire station, some use a school, some use another facility. Whatever the case, doesn't matter. As long as it is designated as a polling place where you vote and cast your vote, you cannot carry your concealed carry weapon in there. Your permit does not authorize that. And number 5, a meeting place of the governing authority of a political subdivision. So this will deal with all the different political parties and the meeting place for those political parties, or the meeting place of the governing authority of a political subdivision. And it includes number 6, as you see, the state capitol building. And so if they're conducting politics there, and it is a meeting place of those governing authorities, then you cannot carry your gun in there under your concealed carry permit, or the state capitol building. Number 7, any portion of an airport facility where the carrying of firearms is prohibited under federal law, except that no person shall be prohibited from carrying any legal firearms into the terminal, if the firearm is encased for shipment for the purpose of checking such firearm as lawful baggage. And so if you are flying with that gun and you have it purposefully checked and it is separated, the ammunition is separated for the gun, that's what's required, and they're both packed separately, you can bring those into the terminal. Now, any portion of the airport facility where the carrying of firearms is prohibited. So it depends on that particular facility in Louisiana or that particular airport and where is prohibited. So usually you can take it in the parking garage and the parking lots and no further. But there may be other areas outside of the terminal that you would be legally able to carry, and you just have to check with that before you go. Number 8. All right, let's look at number 8. Any church, synagogue, mosque, or other similar place of worship eligible for qualification as a tax-exempt organization under 26 U.S.C. 501, except as provided for in Section U of this section. And we'll look at Section U shortly. But you cannot carry with your permit into a church, a synagogue, a mosque, or other place of worship, and except for the exempts under Section U, so unless you're actually permitted to do so. But your regular permit, just as you're receiving just through this course, without any extra training or anything else, you cannot carry your firearm in a church, synagogue, or mosque, or any similar place of worship. So where they're conducting worship for religion, you cannot carry your gun in there. Number 9, a parade or demonstration for which a permit is issued by a government entity. So the parade, the Mardi Gras parades downtown that are permitted in Baton Rouge by the Baton Rouge City, you cannot carry your gun to that parade or in that parade. And then number 10, any portion of the permitted area of an establishment that has been granted a Class A general retail permit as defined in Part 2 of Chapter 1 or Part 2 of Chapter 2, Title 26 of Louisiana Revised Statutes 1950 to sell alcoholic beverages for consumption on the premises. And the rule with this for you is if it looks like a bar, it probably is a bar. So any place where they're serving alcoholic beverages and that is their main business. It used to be you had to figure out if that was how they made most of their money, but you know what a bar looks like. And if that's their main business and restauranting is not their main business, you cannot bring your gun in there. You cannot use your concealed carry permit to conceal carry a weapon and bring it into the premises. And then number 11, any school or school campus or school bus as defined in RS 1495-6. And so you cannot carry your concealed weapon in a school campus, or a school bus. And if you look under O on this same page, you will see that no individual, at the bottom of the paragraph, right before the page ends, no individual to whom a concealed handgun permit is issued may carry such concealed handgun into the private residence of another without first receiving the consent of that person. And so you can't just walk into your friend's house with your weapon concealed. They have to agree that, hey, that's okay. And that simply goes like this. Hey, Joe, I recently got my concealed carry permit. I do have my weapon on me. Is it okay if I carry my concealed weapon in your house when I come visit you? And Joe may say yes or no, and you abide by Joe's wishes, and that's what the law says. Okay, let's talk about church, synagogue, or mosque, or any other place of worship. And this is section U that we referenced just a second ago. And it says the entity, that is the church, the synagogue, or the mosque, which owns the business or has the authority over the administration of a church, synagogue, or mosque shall have the authority to authorize any person issued a valid concealed handgun permit as authorized by the provisions of this section to carry a concealed handgun in the church, synagogue, or mosque. And the way that works is the provision of this subsection shall not be construed to limit or prohibit the church, the synagogue, or the mosque from employing armed security guards who are either certified law enforcement officers or who are authorized to carry concealed handguns pursuant to the provisions of this section. If the church, the synagogue, or the mosque authorizes the carrying of concealed handguns as authorized by the provision of this subsection, the pastor, priest, minister, or other authority of the church, synagogue, or mosque shall inform the congregation of the authorization. Okay, so whoever's in charge or whoever is the leader of worship, they're going to inform the congregation that they have authorized those in the congregation or those in that facility to carry concealed carry handguns. And so it has to be made knowledgeable to the participants. And also, number 4, the provision of this section shall not be construed to authorize the carrying of a concealed handgun in a church, synagogue, or mosque located on the property of any school or school property, which would otherwise be prohibited by the previous positions. So, if you have a school that's run by a church and the school is on the same property as the church, you cannot constitute carrying inside the school because of church carry. And so there are overlapping properties where you cannot make one rule provide for the other. So it is not authorizing you to carry in a church located on a school. So for instance, if you have a state university property and there is a mosque on the state university property, even if you have authorization from the mosque, you cannot carry into that mosque because you're on the school property. All right. Number 5, any church, synagogue, or mosque authorizing the carry of concealed handguns pursuant to the provisions of this subsection shall require an additional 8-hour tactical training for those persons wishing to carry concealed handguns in the church, synagogue, or mosque. The training shall be conducted annually. And it doesn't specify the training, but you do have to have additional tactical training, 8 hours annually, to be able to carry in the church, synagogue, or mosque. And that's additional training, and that is up to the facility and the leaders of that facility, of that church or mosque or synagogue, to contract out and get that training done for all the participants. And then they have to just be able to have proof that they did participate in the 8 hours of tactical training. All right, now let's look at negligent carrying of a concealed handgun. And this is Louisiana Revised Statute 40-1382. Negligent carrying under A there of a concealed handgun is the intentional or criminally negligent carrying by any person, whether or not authorized or licensed to carry or possess a concealed handgun under the following circumstances. 1, when it's foreseeable that the handgun may discharge, or when others are placed in reasonable apprehension that the handgun may discharge. So, when you're carrying it in a manner that it may go off, or when others are placed in reasonable apprehension that the handgun may discharge. Now, I don't know how that would actually look, but basically this is saying, get a good holster, carry it in a holster. Don't throw the gun in your purse. Don't just throw the gun in your pocket, tuck it in your waistband without something protecting the trigger guard. And so it's carried in such a manner that it's deemed unsafe. That is negligent carrying of a concealed handgun. You may have heard of the man in Walmart. He had a .380 pocket pistol. It was shoved into his pocket with his keys. He goes in to reach for something in his pocket, and boom, it goes off. He's charged with negligent carrying of a concealed handgun. Thank God he didn't hurt anybody else. He didn't hurt himself. But still, the gun goes off, and you're charged with negligent carrying of a concealed handgun. So always have your handgun in a proper holster, and that way you won't be charged with a negligent carrying of a concealed handgun. 2, when the handgun is being carried, brandished, or displayed under circumstances that create a reasonable apprehension on the part of members of the public or a law enforcement official that a crime is being committed or is about to be committed. So, you have a concealed handgun permit, but you're carrying it in such a way that you are brandishing it or displaying it. It's not really concealed at that point anymore, but you have a permit, but you're still displaying it or brandishing it. So a permit doesn't give you the legal right to threaten people or to seem threatening to people in a way that they feel they become apprehensive about it, or a law enforcement officer says, hey, something's about to happen here, or it looks like you're about to commit a crime. You don't have the legal right with your permit or under any circumstance to carry a gun in that manner to where you're showing it or brandishing it or in a threatening manner holding it, walking down the street with it possibly out as if you're ready for action. You don't have the right to do that, and your permit doesn't authorize, and it will be considered negligent carry of a concealed handgun. B, it shall be within the discretion of law enforcement officer to issue a summons to a person accused of committing this offense in lieu of making a physical arrest. The seizure of the handgun pending resolution of the offense shall only be discretionary in the instance where the law enforcement officer issues a summons to the person accused. If the law enforcement officer makes a physical arrest of this person, the person accused, the handgun and the person's license to carry such a handgun shall be seized. So, the law enforcement officer in any of these circumstances can issue a summons to you and accuse you of committing the offense in lieu of making a physical arrest. And so he doesn't have to arrest you on the spot, but he can issue a summons, and then the seizure of the handgun is pending the resolution of the offense. So it can be on the spot, or it can be done by summons. But if the law enforcement officer makes a physical arrest, the handgun and the person's license to carry such handgun is to be seized. And so it will be taken if you are arrested. If he issues a summons in lieu of arrest, it may or may not be taken pending the outcome of the summons. And then C, whoever commits the offense of negligent carrying of a concealed handgun shall be fined not more than $500 or imprisoned without hard labor for not more than 6 months or both. The adjudicating judge may also order the forfeiture of the handgun and may suspend or revoke any permit, license authorizing the carry of the handgun. So, if you're found guilty of negligent carry, it can cost you $500 max, and it can cost you 6 months, not hard labor in jail max, and your permit revoked for the carrying of the handgun. So don't negligent carry. Abide by the laws. Get this rule book, as I said before. read it again, know and understand what your responsibility is under the law, and everything will be fine. Okay, that concludes the written portion of the Louisiana Laws and Rule Book. And now we're going to go on to watch a couple scenario videos under the law portion that will help us more understand how the law works with regard to concealed carry. So go ahead and go on to video number 1 in this law section, and we'll see you there.